One of the fundamental elements of contract formation is known as the doctrine of consideration. At its heart, this is quite a simple concept. To enforce a contract, you must actually give something in return for the obligation which the other party has to you. So if I give you an ice cream, and in return for that ice cream, you don't have to give me anything at all, that's a gift. It's not a contract, and it's not enforceable. On the other hand, if I give you an ice cream, and in return for that ice cream you give me money, then that is an exchange and it becomes an enforceable contract. There are a number of types of consideration, but the most basic ones are the provision of goods, the provision of money, the provision of a service, or the promise to provide one of those things. So in that same example, when I give you an ice cream, I'm providing you with goods, and in return for that, you're giving me money. Now, once the court is satisfied that each side has given some consideration, then provided both sides agree to the amount, the court is not concerned with whether the price for any promise is fair. So I could sell you that ice cream for $1, or I could sell you that ice cream for $100, and as long as we were both agreed on the price, the court wouldn't care. All of these rules found fascinating expression in Pinnels Case, a case handed down in 1602 during the reign of Queen Elizabeth I, just a decade or so after the Great Battle of the Spanish Armada. This case was handed down only about 100 years after the printing press first came to England, and so it was still quite a big deal for cases to be reported. And it was a very big deal for cases to be reported in English, because the language of the law in England at that time was still principally Latin and law French. The facts of this case are really quite simple. Pinnel, the plaintiff, loaned £16 to a Mr. Cole. In modern terms, that's worth about £4,200 sterling, or a little north of $8,000 Australian, in September 2024. So not a massive amount of money, but not chicken feed either. So if we think about this in terms of the doctrine of consideration, Pinnel had agreed to lend £16 to Cole, thus providing money, in return for Cole's promise to repay the money together with some additional amount as interest at a later date. Cole was supposed to make a periodic payment of £8 10 shillings, but he only came up with £5 2 shillings and twopence. Pinnel sued for the rest of that periodic payment. Cole argued that Pinnel had agreed to accept the lower part payment which he had made. Now, before deciding whether or not Pinnel had in fact agreed to accept a lesser sum, the court had to decide whether such a thing was even possible. And if we look at it in terms of the doctrine of consideration, the answer is pretty obvious. We have one clear promise, the promise made by Cole to repay the loan amount with a periodic payment of £8 10 shillings. That promise had been secured by Pinnel's consideration in handing the money over. We now have an allegation of a second promise, that is, Cole alleges that Pinnel has promised to accept a repayment of £5 2 shillings and twopence instead of £8 10 shillings. But this would essentially be the same as if Pinnel was making a gift to Cole of the difference between the two figures. There was no suggestion that Cole had given any sort of consideration for Pinnel's agreement to accept a lower amount. So even if Pinnel had agreed to accept a lower amount, that agreement would not be enforceable. It would not have been secured by consideration. The court put it this way: payment of a lesser sum on the day in satisfaction of a greater cannot be any satisfaction for the whole, because it appears to the judges that by no possibility a lesser sum can be a satisfaction to the plaintiff for a greater sum. This has become known as the rule in Pinnel's case. The payment of a lesser sum cannot be regarded as sufficient consideration to discharge an obligation to pay a greater sum. But that's not the end of the story. If Cole's real problem was that he did not provide any consideration for Pinnel's agreement to accept the lesser payment, well then the obvious way around this would be for Cole to have given consideration. So for instance, let's say Cole had gone to Pinnel and said, I can't make that payment of £8 10 shillings, however, I can get you £5 2 shillings and twopence and pay the rest later. Is that okay? Pinnel might have answered, well, you can make that payment, but I need some money in a hurry. So I'll accept the part payment, but only if you can pay a week early. Can you see that in those circumstances, Pinnel would have agreed to accept a lesser amount, but in return for that, Cole would have agreed to pay that lesser amount earlier. Both sides would have given consideration. Both sides get something out of the bargain, and so the promises made on each side would be enforceable. The court put it this way: acceptance of part payment before the day in satisfaction of the whole would be good satisfaction in regard of circumstance of time, for peradventure part of it would be more beneficial to him than the whole at the due day. Similarly, imagine a scenario where Cole had gone to Pinnel, explained his need to make a lower payment, and Pinnel had said, "This is really quite tiresome, old chap, but I'll tell you what, I've always admired that red silk scarf of yours. If you give me the scarf, then I will accept the lower part payment." Again, you can see that each side has given consideration. Each side is getting something out of the deal. The court, identifying consideration on each side, would enforce the promises that each side had made. Again, the court put it this way: the gift of a horse, hawk, or robe, etc., in satisfaction is good, for it shall be intended that a horse, hawk, or robe, etc., might be more beneficial to the plaintiff than money. Can you see how all of this comes back to the question of consideration? If Cole wants to enforce Pinnel's promise to accept a lower amount of payment, then Cole needs to give some consideration for that promise. The consideration could be early payment, the consideration could be handing over some goods, but at the end of the day, both sides need to get something out of the deal. It must be an exchange. If it is simply a part payment, then Cole would get something out of the exchange by being able to pay the lesser amount, but Pinnel would get nothing at all. It wouldn't be enforceable. 400 years later, Pinnel's case is still universally taught to undergraduate contract law students. Unfortunately, however, it's often simply taught as the rule. The rule is the payment of a lesser amount of money cannot be good discharge for a greater debt. Pinnel's case, however, has so much more to teach us about the way that consideration works. Ultimately, in contract law, for you to rely on and enforce anyone else's promise, you must provide something agreed to by both parties in return for that promise. Setting all of that aside, isn't it amazing to think that a smallish loan made more than 400 years ago can still form a key part of our law today?